to still go over. We're going to try to get through most of it. The new stuff that's in your materials I may not touch upon today. That's just some information that I thought you'd find useful. But basically, I think we're good on the attorney approval clause. You just got to make sure that really the cases are very clear. If it's got the elements of a contract, if it smells like one, looks like one, walks like one, talks like one, it's a contract. So that's why, when you have signatures and you have all the terms, basically, you could be entering into an actual real estate contract. Even though it's an offer to purchase, the parties can sue and say, well, this is a contract. He agreed at $335. I wanted the house at $335. I'm suing. Meanwhile, everybody thinks that's a memo of sale and then negotiating one against the attorney's state. And again, there's a lot of materials in here, for your reference purposes. Carbon monoxide detectors.
I'm sorry, I just have a quick question. Rosemary. It's on the wording for the contract. I just want to be clear, we're going to get a new purchase offer in dot loop with new wording that doesn't say,
It's a legal document.
it does say that already.
It will no longer say that.
It will no longer say that. Is there anything wrong when we have a client who's a seller who's desperate to sell, wants a signed agreement, and we're, wanting to follow Article 9 saying we want to get all agreements in writing, that we say in that purchase offer that's not a legal contract, it's subject to a more formal contract of sale being signed. It's already has subject to everything else.
That's the language that I was reading. It's all going to be included now.
Right, but I think that her question is still having the seller sign it.
Listen, as long as the language is in there, and the parties understand that that's not a contractually binding document, it doesn't matter what type of language I come up with, yes,
But
it's
again,
fine.
I want to go back to the claim for a brokerage commission based upon a meeting of the minds, based upon that document being signed.
Right.
So
The
that's why
brokerage commission, right, you got it.
That's why it's our recommendation from before with Ed to not have our sellers sign those.
Right.
Unless our client, the seller, insists that there's something to get them to the next stage. I also have a problem with it as a buyer's agent. I can say to another broker, your form, my seller cannot sign that form. And here's the reason why, and they may want something else in writing, because when I'm a buyer's agent and I've, beat a path to a property that's very hot, and I get my buyer in there, get an agreement on the table, the seller agrees to it, and there's 5 more showings the next day, I'm going to tell them, the attorney doesn't want to draw contracts until you have an inspection. The inspection's $500. You don't have anything in writing saying that you're not number 6.
Question. What's to stop the seller from taking another offer, even if your seller even if your buyer signs it? So, what's to stop them? If it says that this is not a legally binding contract?
I guess it's just having agreements in writing that maybe even if it spells out.
The agreement in writing really, for purposes of trying to establish, it's pretty simple. There's a lot of case law, and it's not simple, but there's a lot of case law that, if you bring a ready, willing, and able purchaser, unless the listing agreement says if, as, and when, and you have certain language in there, that type of stuff. There's really there's no way, you can bind the seller to anything. So in reality, the custom is no one's going to really go after the commission if the seller pulls out and really accepts another, for the most part. You're not going to, it's just going to be another deal. You're not going to kill relationships. This is really just in practice. If a commission, if you bring ready, willing, and able purchaser or seller to the table, and there's tons of case law that goes one way or the other, having a written agreement, you have to really explain to the other side, or to your client, there is nothing I can do. I mean, I tell all my clients, and listen, it's not a great, it's not something that I like telling them, but I tell all my buyers, until I send the contract to the seller and the seller signs it and emails it or mails it back to me, you're not in contract, period. They're like, what do you mean? And I just repeat it again. And then they say, but what do you mean? And I just say it a third time. And by then, you're probably okay, because really, I do it all the time. I send out a contract, down payment, and then I get it mailed back. And you try to find out what's going on. The seller's attorney doesn't call you. You don't know what the status is. And then you get a mail, an email, a package back with the check saying, thank you, but we went with another offer. So, that's the kind of stuff that you probably, and most of the cases say, yes, New York is still a ready, willing, and able state, but they're still going to take into account, what stage you're at. So if you have written agreements and it's conditioned on, inspection and a mortgage and all of that, it's still conditional. So, putting the language in there and they sign it, fine, they sign it. It's not binding to them. It's probably not going to establish a ready, willing, and able standard in the court. So, you're going through a process where you maybe just, let me not shake this thing. Going through a process where it may be just easier to set the, guidelines, set it up front, and so that they're not under a misconception of how the deal really works. You have to say, listen, I've done real estate for 20 years. We're going to submit an offer. They accepted the offer. And tomorrow, if they call me and say they don't, they don't. I mean, that's what, most people know that. If you're straight up with them and you clearly define that up front, they're not going to come back and say, you misrepresented me. But if you don't say it, they're going to come back and say, you didn't tell me that after I, went. And even to me, if I don't have that conversation with them, they're going to come back to me 2 seconds later when I call them and say, listen, I got the contract back and they rejected your offer. If I didn't have that conversation with them 3 times, right, they would be ticked off at me, just in the same way that they would be at you if you don't really clarify what the process is and how it works. And you have to, this goes into another course, and we have a lot of materials. So like I said, I'm going to hold questions to the end of each section, but just a quick point. You have to let them know, if you do an inspection, you're going to lose that money. Have it in writing. I have a DOS complaint that I worked on where they're alleging we want the money for the inspection from the broker, because the broker never told the client that, the buyer never was told. So have it in writing. Say, please note, there's a disclaimer, and I can certainly help out. You can have certain disclaimers on the offer that says, if there's an inspection that needs to be done and the seller withdraws the offer prior to the contract signing, please note that you'll be responsible, so you don't have to worry about all this stuff. If you tell them what happens, they know they're going to put out $350 for an inspection and lose it. If they say, I'm not putting out $350 for an inspection, then you say, then we're not going to do a deal, because every deal now, no attorney's going to allow the 10-day or 15-day inspection, contingency period like we used to do even 8-9 years ago. That's when it started tailing off. But let me start going to the next section. Carbon monoxide. This is just an update in the law. I know most of you here do residential. For the few that do commercial, just note that there's just a distinction between new commercial, existing commercial. You require all CO detectors to be in commercial buildings and restaurants. That's basically the rule. If it's 2015 to the end of, if a building is existing or you have actual building permits pulled, okay, you're considered a pre-existing commercial building. If anything new, say you're in zoning board approval, you didn't pull building permits. Building permits are pulled next month or next week, and we're in 2016 now. It's going to be considered a new commercial building. The only difference is existing. You can use a battery powered. It has to be UL listed. Okay, I think I have the code there. UL 2034. It's a 10-year battery life. You can use that for all pre-existing buildings. It can't be a dual detector like we have in residential. there's a smoke alarm on the property, it has to be a separate carbon monoxide. For all new commercial buildings, it needs to be hardwired, which means it needs to be tied into the central tank, okay? And that's basically the carbon monoxide law, you know, in a nutshell. There's really not much. I've added, you know, sections of the law if you want to take a look at it. There's a couple of exemptions for canopies and some other small, you know, exemptions in the bill. But other than that, we're pretty much, you know, set on that.
Does that include smoke detectors and carbon monoxide for 5 families and higher, or is it considered commercial property?
The definition, hold on. I believe it's... Actually, I don't think the... I'll look it up. It's just so we can move forward.
Yeah.
But it's in the, there's an exact definition of it, and I'll tell you, you know, at the end if we have some time. You have to make sure that the owner's compliant. So if... No, there's no form. It's just a matter of you knowing that this is an issue and that it'll come up. So if he sells and it's not, it's going to delay the closing. So as far as the realtor community is involved, you know, is concerned, you basically just have to make sure the seller's compliant with the new law. I can guarantee you 80–90% of the commercial builders and commercial owners don't even know that this law existed. The update on Neighbor City, basically this was a lawsuit that was involved. It's been, you know, a long-standing lawsuit. You know, we can go through it. I just want to, you know, basically touch upon that it was decided by, it was basically came down on early this year that they granted National Association of Realtors summary judgment motion on this. The Hudson Gateway Association was also part of this lawsuit. It involved the scraping of copyright.
Yeah. So this was a company that was out there, and actually we did have agents within our market center that were contacted by them. They would offer you a referral fee because they would put out a website. But basically what they were doing was scraping data from the MLS, and that was how they were generating referrals to agents. The bottom line to this, and the important part about it, is that the agents had come to me, and I was aware of this, that there was a lawsuit going on, so we did not enter into any of these type of referral agreements. So the bottom line is, if you have a referral agreement that you want to enter in with somebody, you need to come to us first so that I can look at it before we sign on to it. Because, you know, there could be culpability with us through the MLS if we give out the data and allow the data to go to these types of third parties. So we want to know where our data is going.
And, you know, this is just a copyright, you know, infringement case, and basically just establishes that the copyright is still alive and kicking. Neighbor City basically was saying that it's, you know, the fair use doctrine, it's out there, we can use it. It's not. If there's photos, if there's copyrighted materials, you can't just use it, you can't scrape it. And Rosemary points out that if there's any agreements or anybody contacts you, please, it goes through compliance, it goes through Rosemary. You got to make sure you don't sign anything, because obviously you may be giving rights away to something that you don't even have rights to. So that's the major takeaway. But we've been reporting on that for years on that case. Finally, it's been settled and in our favor. The next area basically is the mold remediation specialist. This is a very key area that you should be aware of. I'm going to point out quickly what you need to know. From a realtor perspective, you got to make sure, you know, if there's going to be a mold remediation company taking, you know, if there's mold issues at the house or the subject property, there are now two requirements, two different entities or people that you're going to need to engage. The law says that if you're going to have a mold assessment company do it, that person has to be separate and apart from a mold remediation company. So that's really the takeaway. The fact that now they have to be licensed is, licensing requirements for mold remediation specialists. You got to make sure from your standpoint that you ask for licensing if you're referring, any mold companies to do this kind of stuff. And you have to know that now the seller is going to be responsible if they do subject themselves to paying, whatever any mold issues are. They're going to have to pay an assessment company to prepare a report to say what the issues are. Then they're going to have to pay a separate company to do the remediation. There's a conflict there that the state basically saw that they, that they needed to clarify and make sure that you didn't have the same company doing it because there was just a conflict of an inherent conflict of interest there. And again, there's copies of the actual bill attached or provided. Truth in lending. This is the new TRID rules. I'm going to go quickly through this, but really, I can't even tell you. And I do, 250, 300 bank closings a year, okay? Representing just the bank. I've done 2, okay? Since October 3rd, because most of them all were prior to October 3rd. I have about 15 or 16 pending new TRID applications that I'm doing, and we've only closed 2. The 2 that I've closed, 2 diametrically opposed, okay? 1, the bank said you have to have the bottom number match, all the checks have to match. If it doesn't, we're not closing. We have to redisclose. There's a 3-day business day redisclosure rule. Another bank, the bottom lines didn't match the checks. We asked them, we emailed them, they said, don't worry about it, it's fine. You know what? I got it in an email, I'm covering myself, and that's all I can do. As far as the new ones, all I can tell you is you have to be upfront with your clients, okay? Quick. You got to make sure you tell them, we don't know what TRID's going to involve. I don't know, and I can't tell you. I can tell you with certainty that a redisclosure has to happen if there's bank-related issues, fees that are increased, if the APR goes up in any way, okay? That could happen while you're at the closing, okay? Either a mortgage broker messed up, a fee wasn't disclosed. If something like that happens, you're actually going to be at the table, you're going to adjourn. I'm sorry. You can't say, let's redo the HUD, let's send it in. It's not a HUD anymore, it's a CD. It's even worse. It looks crazier than the HUD. I prefer the HUD. When that came in, I was like, ugh, I want to go back to the HUD. But anyway, the best I can tell you is you got to tell your clients there's no more stack closings. If they're buying and selling, please don't, and I'm with all, due honesty, don't tell them, yeah, we could try to figure out how you can close on the same day. It ain't happening. The problem is even if you can figure it out and it does somehow coordinate, you now have to hope that one closing doesn't get adjourned and then the other one gets messed up because of it. I've been telling all my clients, I've prepared a rider that goes to, that gets attached to my contracts of sale that basically give everybody a 10-day cushion, okay, and basically say, this is, you gotta work with me. So if I'm a buyer, I attach my rider. In my rider, it says, you gotta work with us. I'm not gonna be held responsible for TRID delays, adjournments in closing, changes. If I get a seller to, agree to it, that's great. Most sellers' attorneys, and we go up to Albany, and we sit there in the legal conference. It's about 20 to 25 of us, and we just go around. And half of us, we're arguing with each other. We all handed out riders that we all prepared, and they all laughed because they said, nobody's going to sign this. So far, every one of my sellers has signed it. Why? They don't even know. So I'm good for a little bit. So they figure out what TRID actually means, and I would say January is going to be a big month. I can guarantee you there are going to be huge, huge penalties for banks within the 3 months from October 3rd to now, because I can guarantee you, just like the 2 or 3 that I've done, half of them are not going to be in compliance with the new rules.
And I would say if we're representing the seller, we should probably be proactive with the seller's attorney in getting the document that they're gathering with all the information from the brokers and get that over to the buyer's broker, so that they can sign it. and they have all that information well ahead of time.
Yeah,
So we
what
need
I've
to be
been-
proactive on that.
Yeah, what I've been doing, Rosemarie, is I've been telling brokers, and I just started literally in the last few, several weeks, well, 2 months, but telling them in their offer, okay, in their memos of sales, you have to provide licensing, your license numbers, okay? Provide them for both the agent and the brokerage firm, okay? Most people say, why are we going to give this information? Nobody should know it. Well, it's required on the CD. If we don't give it, you're not closing. So we don't get an approval or a clear to close. So that's kind of the information. We got to make sure you have the correct address from the brokerage firm on the memos of sale or the offers. So that information is given to us ahead of time. As much as you can do to help us get that information on paper, so that when the bank, attorney calls me and says, John, we need the broker's ID numbers, we need this, we need that, I just give them the offer, the memo of sale, send it to them, and they have that information. I can tell you we have to get closing costs and CDs approved at least 10 days, 7 to 10 days prior to any even potential closing date. We send it in, and then they approve it or disapprove it. That may go back 2 or 3 days. I think once the process is gotten used to and we get on, on the right track, we could probably close quickly, provided that there's none of these crazy, issues that come up. So that's my main point here for realtors is, whatever the attorneys ask you for, just give it to them. Don't, make a big deal about it, unless obviously it's not required under the CD, and then you speak to us and see if it's information. Another big issue, and that I always try to just point out, everybody wants a copy of the HUD. That's what, just so you know, the DOS does not require the brokerage firm or the agents to get copies of HUDs at closing. I was actually in the meeting with Whitney Clark when she told us face-to-face, where the hell did you get that ruling? It's nowhere in the DOS regs, but I can guarantee you 98% of the closings I do, every broker says, give me a HUD, give me a CD, give me this, give me that. The thing is if they don't give it to you, the law only requires that a memo be placed in the file of the significant terms of the deal and the closing date, which you can get basically from the contract of sale, the closing date, the purchase price, and that's basically all the law requires. So I've been getting, I've closed, some deals with the CD, and actually one attorney said we're not giving it to the broker, and the brokers were, I was doing the bank, so I didn't get involved, but they said we're not giving it to them. Don't ask me why. I mean, I normally just give it to them. I ask my client first, because it is a document that pertains to the transaction. So I ask my client, buyer or seller, is it okay to release the HUD, and I give it to them. So that's an easy way to do what regs require. You get the HUD, you put it in the file, and you don't have to do this extra memo. If they don't give it to you, it's not the end of the world. You just do an internal memo, just basically covering those items, and you'll be okay.
We have a form that we ask the attorney to sign if they're not going to give it.
That's it. So you'll be covered, but again, it's not required, you won't be held liable, but you do have to have a memo of the transaction, which is kind of the terminology that the TOS regs require. So again, the 3-day business disclosure, you just got to be, and the only other thing that I would point out on the TRID is for new construction. A lot of new construction builders like to put dead dates, steadfast dates in the contract. So they don't like the on or about language, right? So they say you have to close on February 1st, that's it. If you don't, you get a penalty, for every day you close beyond that. The attorneys and also the sellers, the sellers' agents have to tell the new construction builders, listen, there's TRID. I didn't touch it. That there's TRID and that they have to be a little bit more flexible. It's up to you really to try to convince them. I represent builders. I've already told them. They're already saying, yeah, whatever. I'm going to put it in the contract anyway, because if there's a TRID issue, we're all all subject to it. It's not, it's not the buyer's fault, it's not the seller's fault. We're all subject to it unless there's a real reason why it's not getting approved. And that's internal, and that has to be done, dealt with through the attorneys. But sometimes it's the buyer's fault. They're not giving the documentation. One big issue, and I would suggest you tell your clients this so that in case their attorneys don't tell them, don't don't enter into leases or buy another house or do anything that affects your credit between the time you sign the contract and the time you close. I've had 5 deals get canceled, banks withdrawing their commitments because they do an updated credit report search, probably, and I'm not kidding you, probably on a weekly to bi-weekly basis. The minute I've had one person entered into a lease 3 days prior to the closing for a car, the bank withdrew the commitment. Withdrew the commitment. The buyer's going to lose their down payment according to the contract. So just, it's a tidbit of information that I would say, this isn't a legal thing, but it's something more logistic that has to do with TRID, because TRID really, and the Dodd-Frank, regulations, they've really changed the lending landscape. I had another guy who just told me the other day that he closed the TRID deal in 30 days, from contract to closing. If we could do it, God bless, my experience has been probably 60, you thank God, 90 is probably the better window, 120, you're really out there. So if you're within the 120 and 60 day, don't keep calling the attorneys, don't keep calling the buyers, the sellers, and it's just, it is what it is. If you get that one deal that closes quick, thank God, but for the most part, I do a lot of these, so, it's unfortunate. But it looks like it's getting a little better as they learn how to do the TRID and get the CDs approved ahead of time. Going to just quickly go through teams. It really, the key thing that I tell you is they focus on advertising regs. The advertising regs really determine how teams, can function, and how we go ahead. There's legislation that's being presented that would actually define what a team is. Again, like I said, the team is defined in the statute, but it's not defined in the RPL. So they basically, the last 6 months has seen an explosion of teams, really in the boroughs and Westchester and, Long Island. Teams are all over the place.
Well, you can thank Keller Williams for that.
So you have to just know that you really, all the issues, really you have to just, what I tell everybody, focus not on the team, but on the individual sales agent or broker or sales associate. If any reg applies to an individual, it applies to the team the same way. Okay, so if there's any issues, you basically use it as a guideline. There are some issues that we just want to point out to you. A team is not a separate entity. You shouldn't be forming an LLC, and making an entity known as the, John and Anna team, we're the best, blah, 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 and it's John and Anna Team LLC. And then you start hiring employees. That's a no-no. You can't have W-2s. You can't operate it as its own company. You're still subject to all of the brokerage requirements that you're subject to as a sales associate or as a licensed, associate broker. Okay, so really the brokerage firm is what's at the top, and anything you do has to be in compliance with that. We've had companies that are actually, hire employees, are paying W-2s, are W-2ing employees out of that thing, and it really, the law is specific. The LLC law that was enacted a few years ago is only for the purpose of collecting commissions under a limited liability entity for the person who's collecting that commission.
I just want to clarify on that because we've had extensive conversation and direction from Ed in the past. If a sales agent is hiring a non-licensed assistant, okay, they can pay that non-licensed assistant themselves. They determine whether it's a W-2 or a 1099 based on their conversations with their accountant. And it may be paid out of a limited liability company if that's how they're getting paid. However, anybody who is licensed and is working on the team has to be paid through the brokerage.
Through the brokerage, right. So, and again, that's just to clarify, that's exactly on point. If you have a reception, an
Admin.
assistant, an admin, you could actually, pay that expense out of the LLC. Other than that, everything helps. Any commissions or commission splits or any, payment of that has to be done through the brokerage.
And those admins cannot hold themselves out as working for Keller Williams Hudson Valley Realty.
No, absolutely.
They're unlicensed admins.
Right. And you have to be specific that they're unlicensed. If you have any ads, and again, the ad guidelines, if you have any ads that include non-licensed personnel, you have to explain or specifically disclaim that they're not licensed personnel under, either the brokerage firm or the LLC. Branch offices are problematic. This is a new development. As per the Department of State regs, a branch office is not permitted to require the team to pay for more expenses than it would an individual salesperson. So you have to just be careful. That's what the DOS is telling us as of November. They're saying that if you have a branch office and you're trying to have the team pay more than it's fair, more than it would have paid as if it was just an individual associate or licensed salesperson, that they're looking at that as not as being disallowed under the regs. So just got to be careful. Just look at your own internal procedures, and that obviously is on a case-by-case basis, and we just have to make sure that we're in compliance. A lot of times they'll come down with interpretations of the law, and unfortunately, unless it goes to court, we can't tell them that they're wrong unless we can, have a smoking gun and say, oh, by the way, the reg says that you're absolutely wrong. Teams do not exist and should not be included in the MLS data fields. Team leaders and brokers are open to liability. So you can't say in the MLS fields that the teams, it's got to be the individual licensee and the brokerage firm. Teams are not under the view of the DOS. They're not a separate entity or licensed entity. So again, like I said, if you just apply the ad guidelines and the guidelines that apply to, individual guidelines that apply to realtors, you should be okay.
John, can we get a question here?
Yeah.
As we're seeing an expansion of teams, and I feel that we're getting people from Westchester now that are coming into Rockland and vice versa, because you are doing real estate in Westchester, this whole trade thing about the timing of everything, in Rockland we have this, I feel like it's a boys club rule about this 30-day closing. Like if we have a closing date, it's always an on or about. And I've never really understood the clarity, because I thought it was 10 days legally where you can issue time as of the essence. Is that a standard practice in Westchester as well? Because I just like to set the proper expectation for agents that I'm dealing with.
Okay, this is a case. This is from case law. In New York, the leading case, and I don't have the citation, but the leading case is on time of the essence letters. And we all use on or about. Case law is interpreted on or about to mean a reasonable time. In most instances, a reasonable time is 30 days. If you look at the cases, has there been a judge or cases that have been decided less than 30 days or more than 30 days? Absolutely, right? Because it's a reasonable standard. So you're not going to know it, I'm not going to know it. But for the most part, we can say, you got about 30 days. Problem is the case that came out, there was an attorney that sent the time of the essence letter because he knew that the buyer was going to breach. So he sent the time of the essence letter prior to the date of the closing in the contract. The judge specifically said in that case, you can't send out a time of the essence letter if the date in the contract hasn't even passed. Even if you know that the person is going to breach contract, maybe lost his job, whatever the case may be, that case basically outlines what my requirements are and what I tell all my clients. And this you can almost say verbatim. The on or about date, if I've closed an on or about date, and this is just, if I've closed an on or about date in my career, and it's 20 years that I've been doing this, 5 or 6 times, right? Thousands of closings, it's a lot. You know, if I have a Connecticut office in Connecticut, you know, if the contract date is that, you're lucky if you don't close on it. And most of the times, 1 or 2 days will go by. And even there, you're hit with per diem penalties.
Same as Jersey.
Okay? Right. New York, the case laws come out, and this basically is, unless they change the law up in Albany. So I can't send the time of the essence letter out until literally the day after the date of the contract. Do I do that? No. Normally, if I'm not going to know in that situation, they kind of knew that they were going to breach. Most of the times, you know, the bank's delaying, this guy's delaying, whatever it is, they need a survey, something comes up. So I wait a little bit, and then I'm like, are we ready to close? If a couple of weeks goes by, okay, and then I see no movement, I usually call up the attorney and say, I'm going to send out a time of the essence letter. I'm just giving you a warning. Use it in any way that you need to. Just know I'm preserving my rights, because if I have to go to court, I need to have that on file. It's worth nothing at that point, because it's not going to force them to move any faster if they're not going to close. But I can't send it out before, and even in that letter, the court says I have to give them a reasonable time, which could mean another 30 days. My interpretation, if it's an all-cash deal and there's no financing, some courts have held 20 days to be reasonable. I, as a matter of law, of rule in my office, and most attorneys follow it, give 30 days in the notice and say, you have to come to my office on such and such a date, 30 days from today. If you don't close, I'm keeping your down payment. That's it. Am I allowed to release the down payment? No. Like I said before, I have to hold it in escrow. The parties have to fight it out. But that's usually the period of time. So in New York, it stinks. That's why I tell everybody, 30 days for mortgage commitment, 30 days to try to close, probably 90 days is the time frame you should tell every one of your clients. It doesn't help to tell them we're going to close in 45 days when you know there's mortgage contingency, they may need a survey, they're working on, selling another house. So that's the time frame I tell them. The law really doesn't give me much more than what I've just told you, and I just follow it. I got a time of the essence letter back, from an attorney, and he put 15 days in there. And I called him up and I said, really, 15 days? He actually revised it and gave me 30. There's no law, the law doesn't say you have to give me 30, but I called him and I said, give me at least 30. I knew it was my client's fault. I said, give me at least 30. Ended up, they withdrew a commitment on my client. We ended up getting another commitment and closed within 30 days. And only because, I called in a favor from one of my mortgage brokers that I know. So that's basically, that in a nutshell. So there's a lot of information on teams. Ed wrote an article in October about, what you need to do. It's all real in November. Really, we all talked about teams at the NYSTAR conference. It's basically a good outline of what you can and can't do, and all it does is follow the reg, the section 175.25 regs. And it tells you exactly what you can do, what you can't. And if there's any question, again, you're not going to be the one determining what happens. If there's an issue about teams and how they're being used, you have to go to Rosemary, or Rosemary has to basically make sure she takes, a look at it.
And we also have extensive information on teams and how we handle them in our P&G.
Anthony, did you have a question?
Thank you. John?
Yeah.
Let's jump back just real quickly to teams. So a team hires somebody just to do some clerical work, okay? Not licensed, okay? They're paid as an employee. They're doing a great job, okay? We start to add on additional employees, non-licensed. They start to speak on the phone, and now there are certain things they can say or not say as a non-licensed person on the phone. In order to protect ourselves as the agent and the team and the broker, Rosemary, we now say, you know what? It would really be in everybody's best interest if you become licensed. Now, project a year or two down the road, this person is great. You have a couple of other non-licensed employees.
Again, always getting licensed on the Rosemary.
I'm sorry?
as a licensed salesperson under Rosemary's brokerage license.
Right, but these people are employees, we haven't gotten them licensed yet.
If they become licensees,
Hold on.
go ahead.
Okay, we've developed medical insurance for them, internal profit sharing, not Keller Williams profit sharing. They're clearly, by all IRS definitions, employees. Now, because we want to promote them, okay, and protect ourselves against possible lawsuits, because they're talking on the phone, they now become licensed. The minute they become licensed, now we have to terminate them, make them a subcontractor paid by the broker, and risk being sued by that employee because now we have to take away their benefits because we can't provide them because they're not an employee. And they've had medical insurance?
There's nothing, doesn't matter. The DOS is very clear. The team does not function as a separate entity. So even what you're explaining, and I'm going to be very clear with you guys, teams are basically 1, 2, maybe 3 people, right? That's, you know, the minute, and this is a test that really hasn't been focused on a lot, but I know that the DOS has a very strong opinion of it. The minute you start seeing like you're a separate entity, having your admin answering calls for you, which you should be doing on your own, the test is going to change and you're going to be subject to losing a license, and Rosemary is going to be subject to licensing discipline. So you have to be very careful what you think this team is. And I try to explain to everybody, the team is really just a couple of, you know, licensed personnel who operate under the main brokerage firm, okay, to, you know, promote a team type of, atmosphere, a team logo, you know, something like that. The problem is the more you become a separate entity, like all, that's why I'm not saying you can't have an admin and pay. When you have a staff of 16 people and you're issuing W-2s and now you have profit sharing, listen, I'm telling you, keep it very simple. If you want to open up your own brokerage firm, you can get a broker's license and open up your own firm. But the more you do what you're saying, and I'm being honest, you know, the more you run the red light with the DOS and, like, you know, losing licensing.
Right. Well, you know, it's a struggle in New York State because we see this in Keller Williams and we see teams in other states that have different laws in a different situation. I think, unfortunately, the key is in New York, you have to think ahead about how you're going to structure the team. And you need to think ahead not only about the people that you hire, but how you are going to compensate them. And is it wise before you maybe start some type of an employee benefit program, do you get them licensed first so that you're not behind the 8 ball and taking something away from someone, but that you have a business plan and you're thinking about it and you make them licensed and, you know, maybe then at that point you're grossing them up for whatever benefits they're going to be able to buy. I mean, we have the same situation in many states. You know, Keller Williams has a national plan for health benefits, okay, but because we're in New York State, we can't offer it to our people here. So, you know.
It's tough. New York State law is New York State law. You know, I wish I was in other states that allowed, you know, more flexibility, but we're not. So I'm here not to tell you to push envelopes. You know, I'm here to tell you to stay in the envelope, you know, and keep it closed. You know, the minute, and I can tell you, we deal with them, with the DOS a lot, and they give us a lot of internal information that normally would not be, you know, provided to a lot of other attorneys or practitioners. And we get the feel, you know, and I can tell you they're not looking, they don't like W-2, they don't like teams. You know, it's being legislated because we're pushing it, because the Board of Realtors is pushing it, because it's a political, you know, agenda. And the reason why it's gotten so far is really because of the boards of realtors in New York. You know, because we're, you know, we're trying to help the team and the brokerage industry. So, you know, like I said, that's a specific issue. You're running, you know, on the fringes, and you got to pull it back. And if there's any issues, you have to engage counsel, and you have to get them. You know, I'm not here to give legal advice. This is just a seminar, but you have to get legal counsel to tell you what you can and can't do. And if you think you're pushing the envelope, the first person you should go see is Rosemary, your broker, because you're working for that broker. You're not working for yourself.
Right, and we've said all along that, as we grow our teams internally, we may have to change our policies, and we may have to seek counsel on how we handle certain things. So, we have, as a company, we have a very flexible attitude with respect to the teams.
Yeah.
I can just say from this week alone, I had 2 buyers who basically said to me, they spoke to a team and said, our company and my buyers, because they just call anybody, turned around and said, oh, Keller Williams does this, how come you don't? Their perception of team, when it's an individual, and whoever they're speaking to, perceive whatever was said as you, Keller Williams. So that's why it's verbiage and agency.
And that's what it is. That's really a lot of the focus in the law, is that it's, your superior, respondeat superior. This is the brokerage firm. That's what the guidelines say you have to do. So if you're a team, you have to say, we're a team of, right? You can't stand on its own. You can't look like, if it smells like you're trying to, be your own thing and do your own thing, you're probably running the red light, So that's really the essence of it. Again, we're short on time. We only have half an hour, so we got a few sections left. But, if you need anything, there's the article that Ed wrote is really a nice step-by-step analysis of what you need. And obviously, it's not going to cover everything, but it does help out, in that kind of arena. But again, you guys are represented. You have a good support structure, so you don't do anything, without notifying, Rosemary and compliance, officers. Just quickly, I'm just going to go through a couple of decisions. I got 15 or 20 of them that we went over, up at the NISAR conference. I'm only just going to point out a couple of them. In the matter of Troy, the complainant alleged that the Troy failed to provide proof of meeting his CE requirements. What's funny is here the ALJ found the complainant, DOS, who has the burden to prove, the charges by substantial evidence, failed to do so. So the complainant failed to prove, one, that the respondent was ever asked to provide proof of completion of the education requirement, so the DOS never asked him for it. And 2, the respondent made a material misstatement which needs to have been made with the intent to deceive. So those are the 2 elements of this case. Did he make it with an intent? So if there was a misstatement, okay, did he do it with the intent to deceive the Department of State or, the DOS? The ALJ held that if the insufficient evidence was presented by the complainant because there was no intent. They couldn't find, if it's to me, I would have, earlier on in the DOS decisions, if this was a few years ago, I think he would have been fine. Nowadays, it seems like they're a little bit more favorable and trying to see, did he do it, did he just simply check off the wrong box when he put in his certification, or, was there an extenuating circumstance, which leads me into the next case. Here, in matter of Kritikos, basically, they did the same thing. There was a material misstatement. They found that she was guilty, okay, but she said, I'm having health issues. I think she was caring for, an ill dad. She was going through financial hardship. So here they did say, there was a material misstatement. There was an intent, to deceive. They found that she did try to, deceive the department, but because she didn't do it, because there were extenuating circumstances, they didn't hit her as hard as they would have. They just did a fine, said, take additional CE requirements, and basically settled it that way. So these just show the 2 different approaches in pretty similar circumstances on how the DOS tries to figure out what to determine on whether there was a material misstatement. Bottom line, just make sure you take the CE 22.5 courses. I'm sure everyone in this room, because
Well, we require you, when you renew your license, to send us proof of your CE. That has to go to Diane Carroll in New City, or to Erin in Middletown. And, you know, we're expecting that if you're checking that box that you've taken your CE, when you do your renewal online, that you have actually taken it.
Yeah. Do you actually require them to give you copies?
Yes, we do.
Good, good. Most brokerage firms don't, you know, so you gotta make sure, you know, you're good, because if you cut it off now, you're not gonna be at the point where they say, give me the CE, and it's not done, or the box isn't checked off. So you're covered. I put the decisions in the materials as well.
And we actually have had people who have not done it and have been active agents who have been unable to pursue their livelihood for a certain period of time because they could not get their license renewed.
It's a hefty, you know, this is your livelihood. Same thing, the attorneys have to, you know, submit same certification. We have to have, you know, our CLE, legal education completed, and if we don't, a lot of times it won't come up now. It comes up when one, you're audited, or two, if there's a grievance, you know, or a complaint. So, you know, there's a DOS decision regarding realtors conducting unlicensed activities. Here, the salesperson, the respondent was previously licensed as a real estate salesperson. A few years later, however, knowing that the respondent's license had expired, she posted various advertisements on the internet in which she offered apartments. This is really simple, you know. She's actually, you know, offering real estate license services to the public, and she's no longer a licensee. Here, she tried to put the blame on the brokerage firm, saying, I didn't advertise it. You know, the broker advertised these, you know, put these advertisements for this apartment and that apartment. And the DOS, ALJ found that, you know, one, she did get paid $600 for closing one of the rentals. So that payment alone was already, you know, and the broker didn't pay it to her. The client paid it to her directly. So, you know, obviously, these are just easy ones, but you got to make sure. Some of the cases, there's brokers and agents out there that don't even know their license is expired. They just keep working because they forgot to send in the renewal.
Yeah, I want to bring up something on that. I think John Paul mentioned it before, that we do have a lot of brokers from outside of our area now who can come in and show our properties. Our MLS does allow for a day code. My recommendation on day codes, and I think it was Bill Irwin brought this up, as a brokerage, whether we're going to allow it, because that, again, that's an increased risk for us. Okay, if a broker from out of the area is coming in to show your property and it's our listing, I would not give them a day code. I would make sure that you are there for the showing. There's a couple of reasons. Number one, what I just said, the increased risk that we don't want. Number two is they probably don't know the area that well. And there's probably information that you need to be there to give to the potential buyer that they couldn't give. So that's how I would handle it. And the other thing is before you go out with that broker, they need to send you a copy of their license to make sure that they're licensed. Because we have had people who have contacted us, even within my own team, wanting to show properties that turned out not to be licensees.
We'll look it up on the DOS site too.
Yeah.
Again, I can tell you, Keller Williams and some other brokerage firms do send, when they send me the information to prepare a contract, they actually have the license attached to the listing, you know, the memo of sale, the listing. I mean, some offices do send me that information because they probably have it all in their file and say, here, you know, John, here's everything. And I see it sometimes attached as an attachment, you know, just as an aside. So again, the one thing on this case, which even though it's pretty simple, if she would have offered any proof at the hearing, okay, she didn't really provide any proof that the broker had posted, you know, the